Good morning, everyone, and thank you for dialing in to today's webinar. My name is Lucy Quick, and I'm the Digital Marketing Manager here at InfoTrack. I'm delighted to be joined by Steve Johnson, National Key Account Manager at CLS Property Insight. He'll be taking you through the...
Morning, Lucy.
Morning, Steve. Thank you very much for joining us today. So before I hand you over to Steve, I would like to draw your attention to the Q&A tab, which is located at the bottom of your screen. We will be running a Q&A at the end of this session, so please type any questions you might have for Steve, along with your name, into the Q&A box. That way, if we run out of time or your question requires further clarification, we can extract your information and follow up with you directly after the webinar. That's all from me for now. I'll hand you over to Steve. Thank you very much.
Thanks very much, Lucy. And yes, hello, everyone. Welcome to the latest in the series of webinars that InfoTrack have been laying on. And my thanks to them for putting on this webinar with CLS Property Insight on planning and building regulations. As you'll see from the agenda here, we've got 3 sections to the presentation today. Part 1, overview and key issues, where we'll talk through the headline aspects of building regulation, planning permission, and indeed permitted development as well. Then we have a section on a couple of case studies, which will hopefully be informative and something to take away and sort of build into your day-to-day thinking on these topics. And then we'll wrap up with a review of the insurance solution, indemnity that CLS Property Insight is able to provide through the InfoTrack platform on lack of planning and building regulations and some of the key aspects of the policy for you to be aware of. So we'll get straight on with part 1 of today's webinar, an overview of the key issues of building regulation and planning permission. So what are the key differences between building regulations and planning permissions? Well, firstly, they are covered by separate pieces of legislation, as building regulation requirements are set out in the Building Act of 1984 and the subsequent regulations in 2010. And planning requirements are mainly set out in the Town and Country Planning Act of 1990. And with regards to building regulations, they set minimum standards for design, construction, and alteration to virtually every building. And the regulations are developed by the UK government and approved by Parliament. They are mainly to do with having set standards for buildings to ensure the health and safety of people and the conservation of fuel and power, whereas planning permissions are more concerned with the use of the buildings and maintaining the appearance of them and their general impact on the environment. And as you can see on the table on the right-hand side there, the planning permission really seeks to guide the way our towns and cities and countryside develop, and it includes, but limited to, of course, the appearance of the buildings, landscaping considerations, and that sort of general point on the last bullet, the impact the development will have on the general environment. However, most building works will require some form of permission, whether it be building regulations approval, planning permission, or both. It's fair to say it's not always clear how the planning and building regulation regimes differ and interact with each other. So let's take a closer look at building regulations. Some kinds of building projects are exempt from the regulations. However, generally, if any building work has been carried out as defined in Regulation 3 of the building regulations, then it must comply with those building regulations. And this means that the regulations will probably apply to your clients if they want to put up a new building, extend or alter an existing one, provide services and or fittings in a building such as washing or sanitary facilities, hot water cylinders, foul water and rainwater drainage, replacement windows and fuel burning appliances of pretty much any type. So building regulations approval may be required for the erection, alteration or extension of a building, or the installation, alteration or extension of services or fittings, such as central heating and electrics. And in practice, we've seen practitioners and especially clients not realizing that building regulations are required for things such as the installation of spotlights, installation of a log burner or cavity wall insulation, for example. So these are a few different types of work to take note of in your day-to-day work. And also clients will not understand the law in this area and often say things like, I didn't need building regulations for these works. So obviously it is for the lawyer acting to advise them as to exactly what works do require approval under the law and what to do if they haven't obtained any. So are building regulations always needed? Well, the simple answer is no. Works that are generally exempt from building regulations regime include works of a non-structural nature, such as the removal of a non-load bearing wall, or, for example, works that don't impact on the structure or the structural integrity of the building. Also, any works prior to the Building Act of 1984 would not have fallen within the regime. And sometimes, even if an approval has been granted after 1984, it doesn't necessarily follow that you can obtain a copy of the completion certificate, as each local authority differs as to when they may have started issuing completion certificates. So you may have to make a general inquiry to the relevant authority, but also be careful not to invalidate the opportunity of being able to obtain indemnity insurance if that might be required. As with so many insurance policies, and I cast my mind back to my days when I was dealing with environmental reports, there is very much a principle in a lot of the sort of dealing with these issues that one might insure or investigate, but investigation can, if not invalidate a policy, certainly lead to a policy that's perhaps more bespoke to that individual client with certain more caveats or certain more cost to it. So what then is the process of obtaining building regulations approval? Well, from October 1985 onwards, there have been two routes for gaining approval. And this is either directly through the local authority or through a private company approved by the Secretary of State to issue approvals, also known as approved inspectors, under the competent person scheme, where they will self-certify works, issue a certificate via the scheme. So in terms of documentation that's issued to you, you will either be issued with an approval notice followed by a completion certificate from the local authority, or a certificate from an approved inspector under the relevant scheme, such as fencer for windows. So it's important to pay particular notice to completion certificates, because often when works have been completed, building regulations approvals will be provided by the seller, but they may not always have a completion certificate. And this is arguably the most important document. This is because the completion certificate is evidence that the works have been inspected by building control and have been signed off as complying with building regulations. In addition, the initial notice will ultimately lapse, so a completion certificate must be obtained once the works are structurally complete. As a side note, completion certificate is also as important, if not arguably more so, for new build properties. And just because property does not have the benefit of a structural warranty, has the benefit of a structural warranty such as NHBC, it does not always follow that it has a building regulations completion certificate. So for NHBC, for example, you should check the cover note confirms that NHBC covered building control, and if there was no note to that effect, then you should obtain the completion certificate directly from the local authority. So what happens if there is no approval to be found? Well, if no approval exists, there are potential consequences. For example, council can seek a High Court injunction to require the alteration or removal of building works under the provisions of Section 36(6) of the Building Act 1984. This can obviously be expensive for a buyer and also extremely inconvenient. Also, without having building regulations in place, there is no guarantee that the works are up to the required standard and ultimately safe. And this, of course, could be a concern with regards to the health and safety for the buyer and indeed their family. Not only that, but it can, of course, be expensive and inconvenient to remedy a building or to remove offending work. And the costs of that removal process or remediation process can be high. It could also have an impact on the overall value of the property. So for this reason, it's prudent to consider whether or to purchase an indemnity insurance policy, which, although it wouldn't cover the works themselves, it may cover the costs of remediation or reduction in the property value should the need arise. And in part 2, we'll look at some case studies where building regulations approval was lacking and the consequences in those cases. Now, we move on then to the issues around planning permission with our opening slide planning overview. Planning permission or planning consent is permission granted by the local authority to construct something new or make an alteration to a building or to change the use of the property. The local planning authority decides whether a development can go ahead. Recent changes have seen the introduction of permitted development and an increase in what can be built without going through the planning process. I'll do a little bit more on this shortly. The headline steps when working through the planning process are to put in that application, which on receipt the local authority will review, and place the application on the planning register. As part of the process, they will notify the neighbours or put up a notice on or near the site. The local parish, county council or environment agency department may also be consulted. And a report is then produced including any objections. The local authority will then grant or refuse permission via a letter. If refused or granted subject to conditions, the applicant can appeal as a last resort. Planning permission usually takes 8 weeks to be granted, but for unusually large or complex projects, the deadline can be extended to 13 weeks. Planning permission is valid for 3 years from the time that the local authority grants it. And typically for a single dwelling, a planning application costs in the region of £460 odd. For home improvers, an application for extension, for example, in England, typically costs around £206. Now, in terms of permitted development rights are a more relaxed version of planning permission, granted by Parliament rather than the local authority. Now, in fact, some people who initially try for planning permission abandon their planning application and revise their plans so that the work will fall within permitted development instead of the more expensive and lengthy planning permission process. Typically with permitted development, the effect on neighbours of the proposed change or development, or indeed the surrounding environment, is likely to be small, although, as we'll see from one of the later slides, that may well be something that some neighbours will disagree with. Certain projects won't need planning permission and instead fall under permitted development rights, and this can include items such as extensions or loft conversions, the addition of solar panels or roof lights of one sort or another. Now, as I mentioned, permitted development rules have recently been relaxed, and the general view is that while this obviously creates a lesser burden on the planning authorities, and to begin with, obviously a fewer number of applications coming to them, and actually creates a sort of environment whereby homeowners are more incentivized to carry out development on their properties. The view is that it could lead to more disputes between neighbours, even where development complies with the newly relaxed rules, as well as more issues flagged to the local authorities subsequent to them being developed, and at a later point, more enforcement actions taken where the guidelines have not been followed. And as you can see from the example on the slide here, the extension on the left-hand side, which purports to conform with the new rules compared to that conforming with the existing rules, is sizably more larger. And as you can see, the practical result of that extension is greater shading to the neighbouring property and indeed to their garden as well, and a restricted outlook from the house, which is now looking at a far longer wall than would have been previously permitted under permitted development rights. So that potential for house number one to sizably increase its property has to be balanced with the potential for house number two to be somewhat dismayed at the construction that's now going to be taking place next to them. Now, when is planning permission required? Now, this is this huge topic clearly, and very often there is no black and white answer, as there are many conditions and limitations which would specify whether planning permissions are required. So, for example, demolition, we note there that planning permission is likely, the third one down. Prior approval may be required under certain circumstances, particularly where, as we mentioned a little bit earlier, it may be demolition of an interior wall, which is load bearing, therefore in need of some form of NC, some form of permission. Loft conversions, planning permission required, unlikely. This would be considered permitted development subject to limits. But again, those limits can be quite wide-ranging. There is a debate going on in our street, fortunately not at our end of it, but in our street at the moment about a loft conversion, which includes the building of dormer windows, which actually have the potential, so the view of those people objecting to it, to decrease the privacy that they have, and therefore the debates about that loft conversion and the permissions granted to it have been going on for some time and are likely to continue as well. Something like a self-built home at the very bottom, planning permission certainly be needed there, as is associated with the land and should be applied for before or after land purchase. One would generally say it's worth getting outline planning permission before, given that if you purchase land with the expectation of building on it, only to find that you can't build, that causes huge problems. And those of you that have been sort of tracking case studies around this may well have seen a case that happened 7 or 8 years ago now, of a farmer who built a substantial property on his land, then covered the whole thing, or certainly the road facing side of it, with hay bales and various other things, in the hope that the time would expire under which the local authority could make objections to the fact that he hadn't sought planning permission to build this substantial, I think it was a sort of 5 or 6 bedroom property. And a very extended legal case then ensued, ultimately concluding in favour of the local authority, who were then able to enforce that this farmer had to entirely take down the property that he'd hidden behind these hay bales. So yes, seeking to build a property without some degree of planning permission on it is a pretty bold move. Now, we move on now to the case study section of our webinar, and I hope these case studies provide some really good illustrations as to the practical problems that can arise where there is problems associated or lack of planning permission and or building regulations. We start with Cottingham versus Attiboa and Jones. The background to this is that in 1993, Peter and Julie Cottingham bought a house on which the vendor had undertaken significant renovations in the mid-80s. Now, structural problems were overlooked by the surveyor, which were linked to the building works, were discovered shortly after, unfortunately, their purchase had completed. Now, inquiries revealed that the vendor had failed to get necessary building regulation approval and had also lied about it pre-contract inquiries, claiming falsely that they had got consent but no longer had the copy. The claimants contended that they were entitled to damages for the cost of rectification works to a sum exceeding £40,000. And when this went to court, the court found that the buyer's solicitors should have discovered that the 1985 renovations did not have building regulations consent. The buyer's solicitor argued they had made the inquiries recommended by the Law Society's 1993 conveyancing handbook in asking whether building regulation consent had been obtained where such work had been undertaken within the past 12 months, which of course was not the case given that these renovations took place in the mid-80s. The court response essentially said that they could see no justification for limiting the inquiry to work done in the preceding 12 months, and that this was based on an incorrect assumption the planning authority could not bring proceedings for works older than 12 months under the Building Act of 1984. Now, the outcome, when the vendor had been unable to provide a copy of consent, the solicitor was wrong to have left matters there. The solicitor should have made inquiries of the relevant authority, and they would have then ascertained the failure to obtain consent, and at the same time would have unearthed the vendor's misrepresentation in pre-contract inquiries. This case is unusual in that as time had expired, the prosecution took no action under the little used section 36(6) injunction proceedings, which has no 12-month time bar. So to be absolutely safe, the conveyancer might have to engage in extensive correspondence with a view to checking precisely what works were done and whether these matched up with documentation. Our second case study leads us to a conservatory on the back of a quite routine residential property. This conservatory had been built on a property with no apparent planning permission or building regulation approval. Now, as the conservatory occupied more than half of the garden space, it did not fall under permitted development. The purchase was undertaken from a mortgagee in possession in normal pre-contractual inquiries could not be made. As a result, an insurance policy was provided to cover the lack of building regulation and planning consent. And several years after the purchase, the insured received a letter from the local authority threatening enforcement action. So what actions did the insurer undertake? Well, it engaged with the local authority to discuss all avenues. And I think this is one of the points about indemnity insurance that is worth making. Clearly, when you take a policy, whatever the cover, whatever aspect of cover you're looking to provide, there is potential financial recompense for a whole range of different circumstances should the policy be invoked. But very often the value of the policy comes not just from that financial cover, but also the access to legal and other expertise that it may bring. And very often we found policies where, for example, the financial payout to the insured party may be £2,000, £3,000, £4,000, for example. But actually the value of the legal advice that they've been able to access under that policy, were they to have had to pay for that themselves, would have been considerably more, up into the tens, 15s, £20,000 in some cases. So that practical engagement by a professional with the local authority on behalf of the insured is a very significant part of the sorts of cover that CLS provide. In addition to that engagement with the local authority, the insurer hired a surveyor to assess the potential options for remedying the situation. And having exhausted all of the potential options, an agreement was then reached with the insured to settle the claim, with the insurer meeting the costs of demolishing the conservatory as required by the local authority. But it's also notable that the policy then provided the insured with compensation for the reduction in the market value of the land. As you can imagine, the loss of that conservatory certainly did reduce the value of that property, but that loss in value was covered by the insurer. So two hopefully quite useful case studies there. And we then move on now to the insurance solution, which as I say are available from CLS via Infotrack. So firstly, why would we insure this type of risk? Lack of planning, lack of building regulations documents. Well, indemnity insurance for planning and building regulations can cover the possibility of enforcement action being taken regarding a whole host of works carried out at the property, either where the appropriate documentation is missing or has not been obtained in the first place. And this can include simple works like boilers or windows, or works of a more structural and significant nature, such as loft conversions and extensions. Insurance will also cover a lender, and obviously lenders are also concerned about potential enforcement action from a local authority, particularly if they have to repossess the property in the future and the impact it may have on any resale if building regulations and planning permissions do not appear to have been obtained for works done at the property. So our insurance solution for lack of planning and building regulations provides cover where there is an absence of planning and or building regulations of respective works carried out at the property. The policy provides cover for the lack of breach of planning permission and or building regulations approval, conservation area consent, and listed building consent. The limit of indemnity that is covered is the total requested limit, which usually equates to the property price or property value. And this amount will increase to match actual increases in the value of the property in the future, up to a maximum 200% the sum stated. The period of insurance cover that's offered is from inception and continues to cover the property in perpetuity. I should also make the point here that the insured should always be made aware that they must not discuss the insured works with any relevant authority without the consent of the insurer, due to the risk that this could prove to be a willful act and invalidate the policy. When acting for clients, it's also particularly important to inform them of what is and is not covered. So if a policy is triggered, if enforcement in action is taken against the insured, and if that happens initially, we will respond with a legal challenge. And in the worst case scenario, as you saw in the previous case study, we will pay out for the losses in respect of works having to be rectified or demolished. And the policy will also cover, as I mentioned, or may also cover the diminution in the value of the property. Now, as already mentioned, the policy does not cover the works themselves, nor provide a warranty for things such as boilers or window, or any other warranty for that matter. It also isn't triggered, say, if a tradesman or anyone else spots a potential breach of building regulations. It has to be done. It is only triggered in response to an enforcement action taken by a relevant authority. Now, turning now to what is actually covered under the policy. So if the policy provides cover for where there is no documentary evidence for planning permission and or building regulations, and it also does cover lack of certificate should that have been issued under the competent person scheme for works such as new boilers, windows or cavity wall insulation. And it's interesting to note that a single policy can cover multiple issues as highlighted on the slide. So if there are various certificates missing, all of these can be covered under the one policy. So what are the consequences of not insuring? Well, a breach can, of course, cause financial loss if the local authority issues an enforcement notice. That could lead to a reduction in the sale price or the overall value of the house. And there could be a financial loss through having to rectify any works or having to comply with an enforcement notice. This could impact on a property owner's financial situation and, of course, ultimately lower the value of the property, which could in turn impact on a lender as well. The worst case scenario, if the works relate to the property as a whole, it could become unsaleable or unmortgageable. So you can see why taking out a relatively low cost title indemnity insurance policy in comparison to taking on any risk is usually one of the best options for the client. Now, at that point, my thanks to you for attending the webinar. I wanted to flag up at this point that there is a further webinar that Infotrack are putting on. CLS will be presenting on understanding restrictive covenants on Tuesday, 23rd of November, 11 o'clock, and we hope you can join us for that. And I think I'll bring Lucy back in now. Lucy, do we have any questions?
Thank you, Steve, for that. Yes, we do. So we'll get straight into the Q&A. So the first question is, if a wooden extension has been used with no foundation, no wall removed, would this be permitted development?
Right, so on that, I'll have to go back and check with our planning consultant, but if you're happy to capture the question, Lucy, I can have that answered. And what we're going to be doing is sharing the answer to any of these questions with everyone who's attended. So thank you for that.
Perfect, thank you. What is the difference between permitted development and prior approval?
And once again, I'll consult with our planning consultant on that and come back and answer that for the audience as a whole.
Perfect. And we have another one. Do you have any recommended reading around this topic?
Yes, we do. I'll pop a list of the documents that we access or the guidance that we have from our planning consultant alongside the questions. There's also a series of training courses that we often refer people to. So again, I can put those onto a list and send those around as well.
Lovely, thank you. And actually, just to confirm what Steve said, I've had a few queries about the recording. So I will be sharing the recording with you after the session, so you can refer back to Steve's notes. We have another question. Is it 3 meters we don't require planning?
And still rather permitted development. Yeah, typically.
Sorry, I was going to say the question. Yeah, sorry. Yeah, is it 3 meters we don't require planning?
So typically, if something is under presently, if an extension is under 3 meters, subject to a certain percentage of the land into which is being extended, then it wouldn't require planning permission. It'd be carried out under permitted development or building regs. I can expand on that again. I'll go back to our planning consultant to sort of capture the fine detail of that.
Thank you. We've had another question about, are there any training courses about planning that you could share that would be useful? Yeah,
so alongside the documents and the reading material, there are some really good training courses out there which I can refer to as well. So I'll give you a list of those in the follow-up document.
Thank you. Before completion certificates were issued, what documents were issued?
Lucy, I'll have to refer that back to our planning consultant, I'm afraid, please, if that's okay.
Yeah, that's all good. we've had a couple more questions come through. On a new build, NHBC covering building control, does this cover the new boiler, electrics and glazing, or should the developer issue compliance certificates for these separately?
Yeah, Lucy, I'm afraid I have to refer you back to my previous answer. I'll need to get that from our planning consultant if that's okay.
Yep, all good. Got a couple more that have come through. Does working from home need planning permission?
No, no, I do hope not. Otherwise, a lot of the country is going to be in serious trouble. But no, unless you're actually operating some form of business directly from your, directly from your property. But no, office-based, working out of your home office or a setup in your bedroom or your kitchen, no, shouldn't need planning permission.
We've had another one. Does a Velux window in the roof require planning permission?
Typically, that can be done under permitted development.
Thank you. I'm just seeing if we've got any more. We've had another one come through. What if sellers fail to provide written discharge of conditions? Should the buyer in all instances contact the local authority to obtain confirmation of written discharge?
I think that then comes back to the balancing act between pursuing a resolution to an issue at the point when you have an interest or potentially starting to have an interest in the property, or having an insurance policy that would cover the subsequent issuing of an enforcement notice by whoever the relevant party is. So we've certainly come across both circumstances whereby someone has carried out an or triggered an investigation with a local authority and then sought insurance and hasn't been able to get it because obviously there is now notice that's been given to the local authority of the potential presence of an issue. So I think in some senses that's a decision for the home buyer of do you investigate or insure. There's no right or wrong answer to that. Both have sort of consequences to them. But if the buyer has a significant concern that a feature may need to be remediated to the point where, as I say, it significantly changes the property or devalues the property, then they may wish to carry out that investigation. If, on the other hand, they just want to get in, it may well be that insurance is the best route. So there's no black and white to that, but they just have to be aware that investigation may lead to the inability to get insurance at a later point.
Okay, thank you. If building regulations have been granted, but there is no completion certificate, should indemnity insurance be taken out?
Yeah, we would suggest, it's not for us to say it's an absolute, but we would certainly recommend it as a course of action. I think, as I mentioned earlier in the course, the completion certificate is really the critical document to evidence the fact that work has been done in accordance with the correct regulations. So if there is no completion certificate available, then yes, there is still a residual risk associated with whatever the development or build was. And for that, insurance then provides a way of managing that exposure for the client.
Thank you. We've had a question regarding conservatory area. Is permitted development allowed?
Again, would you mind if I come back to you once I've gone to our planning consultant?
Yep, no problem at all. We've had another question. What guidance can you give for a leasehold property developed in a Grade 2 listed building and not all consents are obtained if lender will not accept IP?
Will not accept IP. Would you mind expanding on IP? Oh, is that insurance policy?
Yes.
Sorry. Okay, that's grand. Well, again, I'll seek guidance from our planning consultant on that and come back to you.
Lovely, thank you. Just looking, we've had another question. If there has been a raised decking in a back garden that was removed and a new construction was installed, being about 3 meters by 10 meters, would that require planning permission?
That would depend on the scale of the property from which it's protruding, and also the percentage of land that the development is then going to be taking up. So if, again, this is coming back to one of the earlier tables, the regulations are, and how they interact with each other can be quite a sort of a subtle point. And I say certainly the percentage of land that is taken up by an extension into a back garden is a factor as to whether planning permission is required or whether it can be completed under building regulations, quite apart from the size of the construction itself.
Thank you. Just going through and seeing if we've got any more questions. We've had one here. Can I obtain a CLS lack of PP/BR's policy as opposed to a CLS lack of conservation area consent policy?
Yeah, absolutely. So we provide both variants. So the commonest policy that we sell is lack of planning, lack of building regulations. It makes up a significant proportion of our sales. So yes, that can be sought from us.
Lovely, thank you very much. I'm just seeing if there's any other questions that have come through. I think that is it for today. Just looking at the time as well. So I think we will leave it there. If we haven't been able to answer your question online, fear not, we will follow up with you directly after this session. And as I said earlier, we will be sending out a copy of the recording and Steve's slides, so you can refer back to his notes as well. I would like to say a big thank you to Steve for your time today. I hope you all found this session informative. If you do have any other questions about anything you've seen today, please get in touch with your account manager who'll be able to assist you, or you can use the contact details that are on your screen now. And as Steve mentioned earlier, he will be running another session in November covering restrictive covenants, which you can register for via our website. And I will include a link to that as well afterwards. All that's left to say is thank you so much for joining us. I hope you have a lovely rest of your day and a lovely rest of your week. Thank you very much.
Excellent. Thanks, everyone.